Elslager?
May it please the court, Chris Elslager appearing on behalf of the state. At the outset, I want to advise the court that my co-counsel and I, Natalie Chalmers, are going to split time. Or this is the plan that we had before we got here, at least, not knowing what the arguments of the opposing counsel were going to be. The way we split this up was each of us was going to take 30 minutes of our time. I'm going to handle issues 1, 2, and the prosecutorial error issues, and she would handle all the rest. It looks like I drew the short straw, though, because my opposing counsel only addressed issues 1 and 2. But you know, we'll, to the extent the court may have questions on those other issues, I will defer to Natalie. Get to those. I'll start with the first issue, the denial of a continuance, or at least actually the granting of a continuance that was not as long as defense counsel wanted. The standard of review is abuse of discretion. As the court knows, that judicial discretion is abused when judicial action is either arbitrary or is based on an error of law and fact, or law or fact, and there's no allegation here that there was an error of law or an error of fact, so it's simply a matter of defense argues, or Mr. Flack argues that the court acted arbitrarily. But if you look at the, if you look at the record, clearly there was no rush to trial here. The defense had 3 years from the time Mr. Flack was charged and 2 years from the time of his arraignment to get ready for trial. And the judge did not, myopically stick to his schedule. When the defense brought concerns to the judge, said they needed more time, he did grant them more time. And if you look at what he said, what he articulated, indicates a very careful and reasoned balancing of the competing interests involved. And he initially gave them an additional 5 months. And then when they came back and asked for more time, again, he listened and he articulated his reasons for not wanting to extend the trial, the concerns that to both sides, and the concern that maybe some of these issues would never get resolved no matter how much time he provided, and balanced those carefully. And then ultimately he still gave the defense more time. It just wasn't as much as they wanted. So I think at the end of the day, when you look at that, you cannot conclude that the district court acted arbitrarily or unreasonably or fancifully.
Counsel, I had some concern about the fact that the agency didn't seem to be held to task, if you will. Part of the evidence was that defense counsel had lots of cases, lots of other cases, and also ultimately that they lost their investigator, their paralegal. That seems unimaginable to me, to attempt to try a capital murder case without an assistant. Do you see some criticism the court should have made on bids, or something the court should have done?
Okay, so when you say agency, you're talking about bids.
To be reasonable, yes.
Well, I don't know how much insight. I know they told the court at least some of what their challenges were, but at the same time, the court, responded back like, well, you've had all this time, and it's not like they didn't have investigators, they didn't have counsel. I mean, their complaint now, after the fact, seems to be that, well, they just weren't experienced, and I guess they weren't good at their jobs, but they had plenty of time. And I think the district court was right. At some point, you just can't keep kicking the can down the road. You've had time to do your job. And that's why listening to the opposing counsel's argument almost sounded like they're making an ineffective assistance of counsel argument, not an abuse of discretion argument. The judge, he took all of that in, and if you look at what he articulated, he acknowledged those issues and he gave them more time. But some of their complaints were, well, we haven't had enough time to build a relationship with Mr. Flack's family, and the judge was like, well, at this point, you've been going for a couple of years, and if you haven't, you may never, a continuance, an extension of time it may not solve that issue. The court also noted that some of their issues that they wanted to investigate were really related to mitigation. Well, the mitigation phase was further on down the road, and they could still have those investigators work that stuff while the trial was going on and so on. So the judge weighed all of that. and came to a reasoned conclusion, gave them the amount of time that the judge thought was fair to all the parties involved. I mean, there's competing interests there. There's, the public and the state have rights too, but the judge really deferred, I think, a great deal to the defendant's rights, and you see that in what he articulated. And he ultimately gave them 3 years to prepare for trial. And I think, as members of this court have pointed out, at some point, you got to go to trial. I mean, there's always going to be stones left unturned. The standard cannot be that no stone is ever left unturned before you get to trial, because we would never get to trial. The defense attorneys are always going to find a reason. There's something else that they need to look at, that they would need more time. And at some point, the court has to say, look, as a matter of reason, I mean, we have to be reasonable. We have to come to trial at some point. And that's what the judge did here. And again, it's not like he acted arbitrarily. I mean, he went at length to explain what he was considering, all of the balancing of the competing interests and so on, and asked lots of questions of counsel. Well, can you do this? Well, if you do this, and the court said, look, if you need any assistance from me, if you need me to sign orders, if you need, anything from the court, I'm open. I'm here for you. Just let me know. The court really bent over backwards to help the defense get what they needed and gave them plenty of time. I mean, ultimately, if they weren't ready after 3 years, that's perhaps on them. It's not the court's fault. The court certainly did not act unreasonably, and that's the standard. Was the court arbitrary or unreasonable? And again, I don't think anybody could conclude that from this record.
Counsel, I think we often see language in opinions that suggest that death cases are different. Now, it doesn't mean that our good cause standard changes here, but does our analysis or do the factors that establish good cause change in a death penalty case, or should they? And if so, in what way?
Well, ultimately, claims like, due process is due process. There's not a different due process for death penalty cases than there is for other cases. There's not a different standard in the law for any of these cases. Contextually, I think it does matter because every case is different. Contextually, I mean, certain, white-collar crime cases may take more time because they're so complex and so on, have such a huge record. So, whether a judge there grants a continuance or not, depends on the context of the case. So, yes, I think you have to look at the context of the case. Certainly, in the context of this case, 3 years should be enough time to prepare for trial. And again, it's not like the district court judge said, nope, that's the calendar, that's the date we set, we're sticking to it. The judge listened, considered defense counsel's motions and their concerns, granted them more time. Then when they brought up a second motion, at first the judge said, well, no, I think if you guys, if you do your job right, you ought to be able to get this all done. I'm going to deny it, but I'm going to leave it open if you want to. If you can't get it all done, you can file a motion again. So the judge didn't foreclose relooking the issue. So then it was brought up to him again, and he did relook at the issue. And again, he granted another further short extension to get them to help the defense get everything they needed. So again, it's not like this judge, got rigidly and myopically affixed to the date that he set. I mean, he worked with counsel. He considered all the competing interests and came to a reasonable accommodation as best he could on the trial date. And
you could clarify for a minute. You keep talking about 3 years, 3 years, 3 years, and Mr. Clayton is talking about 7 months. Is it what happened was you had a capital defender who was very experienced, who retired. Is that right?
that's correct. I believe so. I think.
And
Mr.
at what
Evans
point did he retire?
I don't know if I have that in my chart. But yeah, he was. I mean, the 3 years comes from the time that defendant was charged, and then like within a few days of that, Mr. Evans was appointed, and then about a year later. Flack was arraigned, and Evans wasn't by himself. Other attorneys and staff were assigned, and somewhere in there, Evans did retire, and that was something that the trial court took into consideration. If you read, I quoted it in the brief, the trial court said, yeah, that concerns me, and that's part of the reason why he gave them more time. Again, this isn't a case where the trial court denied continuances. The court granted continuances. The beef that Mr. Flack has is just he doesn't think it was long enough, but that's I think.
Right, so when Mr. Evans left, at the point that we're talking about 20,000 pages of discovery, 500 discs, and I can't remember what else there were, and that they told the judge they haven't even had a chance to review all that discovery, let alone investigate any of it. I just want to make sure we're putting it in a context of the counsel that was going to try the case didn't have 3 years, right?
Well, I would submit that when it wasn't that Mr. Evans was the sole guy on the case, and then he left, and then brand-new counsel came in and just dropped in brand new and had to start afresh. They had already been co-counsel, I think it was Frieden, I can't remember the names of the counsel, but co-counsel had been working with Mr. Evans for several months before Evans retired. So it's not like Evans retired and all of a sudden we got to start all over again. That wasn't the case. And the investigators and the staff for and I don't know what the staff they have with the appellate defender's officer bids, but they've got staff. It's not like they all quit at the same time. One man quit, one man retired.
Right, and then he got a chance to work with Mr. Evans, but then he also had 30 to 50 other felony cases on his docket, right?
Well, I don't know. I don't know.
Well, I mean,
that's what they say. I don't know what the caseload was for all of these individuals, but obviously all attorneys carry multiple cases. So yeah, I mean, sure, I'm sure they had other cases that they were working. But again, it's not like Evans was the only guy working the case, and then when he retired, they had to start all over again. That's just not the case. So yeah, there was a change in counsel, and the district judge acknowledged that, and that was part of the reason why he gave them an additional 5 months over the, I think, 14 or 15 months he'd initially set. So again, it's not like the district court acted arbitrarily or unreasonably. The district court acknowledged that, took that into account, and gave the defense more time. So again, it's a matter of looking at the trial court and saying, was this judge unreasonable? Was he arbitrary? And no, you just can't say that based on this record. If there are no further questions on issue 1, I'll move on to issue 2. A standard of review, you review the facts below for substantial competent evidence, and of course the ultimate question of law is de novo.
How do we do that?
That's the problem that the court already identified is because the issue wasn't raised below, or not raised in this fashion, you don't have any findings of fact to weigh or to look for substantial competent evidence. And I think, my opposing counsel is basically asking this court to be a finder of fact. But the district court was the one that would have been able to see the testimony of the officers, would have been able to assess the evidence firsthand and make that and properly in our system. That is the forum for making those findings of fact. So you don't have those.
But we've got a tape,
And
there's no dispute about what happened or what was said, right?
That's true. That's true.
And so what we have consistently said, when the facts are all undisputed, we just move to de novo.
Yeah.
So the issue is going to be whether there was an unambiguous signal or statement, one or the other, maybe both. And so, the defendant said their best case, their first case they listed among many was the Walker case from this court. But of course, Walker, the defendant, said during the interview, "I'm done talking, man."
He said a lot more.
That's when the notion is a right to remain silent, and you say, "I'm done talking," we're pretty good on that one. There are 2 exchanges that I want to ask you about. And in turn, I really want you to kind of put this in terms of the case law that you're relying on. So there are 2 that bother me. One, when our test is trying to figure out what reasonable detectives would have taken from the conversation. One, and it's on page 25 of Exhibit 3, which is the first interview, where he says, "Take me to jail." The next thing that Detective Alexander says is, "So you're going to leave Lana out there for nobody to frickin' find." That's at line 23 on page 25. My point with that is that communicates to me that the detective knows this guy doesn't want to talk anymore. And then, just on the next page, a couple of lines later, he says it again, take me to jail. Detective Alexander says, Kyle, this is your opportunity to help yourself. Again, to me, that's the detective trying to talk this guy out of going silent. You're not going to help yourself if you go silent. That's what that's telling me. Now, how am I wrong?
And if I can add, because just a few lines later, after where Justice Biles finished, there's an exchange where Kyle says, take me to jail. And the response from the detective is, okay, Kyle, let's help yourself, okay? Same sort of response.
Well, the first thing, before the first thing I want to get across is that, you know, the standard is he has to unambiguously, unequivocally invoke his rights. And as, you know, the best way to do that is to say, you know, I'm done talking. I want to end the interview. I don't want to talk anymore, something along those lines. He didn't say that. I mean, that's the first thing. I mean, he did not use the clearest and most unequivocal language in the English language to stop the interview.
At one point, I mean, I don't want to interrupt you because I don't want to lose that train of, but I just have to say, when, just before these instances we've talked about, he says quit. How much clearer can, I mean, quit seems pretty clear.
I'd have to look in the context of where he said that, because he had a tendency to say things like that and then just keep ranting and talking.
I think I may be wrong, but my recollection is that the detective stood up and went to the door. But I have trouble with that in that the detective might not have heard it because of what was happening. I mean, I get that context, but.
Well, I don't, and I've just noticed in looking at what's in the appendix here, I think our page numbers are off, so I couldn't find exactly what you were mentioning there. But I would essentially respond in the same way to all of these, is that when you look at these statements, one, they just were not clear, and there's a lot of different ways you could have interpreted it, and there's the way that the police officer interpreted it, as he later testified in one of the hearings. And one of those, this is essentially an ultimatum by Mr. Flack, not saying that he wanted to quit the interview, but it's a negotiating tactic, which, you know, as I cited the People v. Peralt, a couple of decisions from Michigan and in the federal habeas case that reviewed it, that it's basically simply, it was used as an ultimatum to tell the police, look, change your line of questioning or we're done, or I don't like where you're going. I want to redirect the interview somewhere else.
But doesn't he have the right to say stop?
He does, but he didn't. I mean, he has the right to say, I want to quit the interview. But the problem here is he never said that. He made these references, well, take me to jail. Well, if this is the way we're going to be, take me to jail. You guys do what you're going to do, stuff like that, that did not really fully indicate that he wanted to stop. I mean, you could interpret it that way, but the thing is you could interpret it other ways, which is the point. It was not unambiguous and unequivocal. It could also be, as we suggested in the brief, just a kind of a hyperbolic effort to basically say, look, I'm telling the truth, okay? That's it, I'm done. Take me to jail, I'm telling the truth. Because why else would somebody say, take me to jail if they weren't telling the truth? Because, if they were lying, they'd just make up something else, right?
But why else would the police, this is where I got frustrated all last week on this issue, because I really don't care how the lawyers want to characterize what happened. I know what happened. I watched it. I'm trying to put it in the context of the case law so I can decide which way this goes. And here, when our case law says that we're supposed to consider what reasonable police officers are going to say, I got a police officer here who seems pretty strongly to understand that this guy wants to stop, and she is saying, help yourself, Kyle. And that's a signal to keep talking. And so when my measure is how, police officers are supposed to take this, I got a police officer here that's in 2 instances, and maybe 3, is pushing back on the notion of the defendant being silent. And I'm troubled by that.
And we have the police officer's explanation in one of the, I'm citing volume 16 here, page 82. He explained, he said, Flack, on a consistent basis throughout the interview, Anytime we began asking questions in regard to LB, he became upset. Visibly, his face would turn red. He would clench his fists a couple of times, or a couple of times he hit the table. This was his way, in my mind, with the way he said it, is he was giving me an ultimatum. Either I stop this line of questioning or he's going to stop the interview. That's how the police officer took it. And that's a reasonable, I think that's a reasonable view. And it's a view that has been accepted by courts, as I cited. And in
Counsel, I'm sorry to interrupt, but a quick clarifying question. Is what you just said an undisputed fact in this case? Because we've talked, and opposing counsel has talked about, this is de novo review, we have undisputed facts, but this exchange between Justice Biles and yourself raises that question in my mind. Are we just looking at the video, or there's testimony that later adds color, if you will, to the facts in the transcript and the video? So how are we supposed to understand what's an undisputed fact and what's not?
Well, now we've circled back to what I started with in the question from Justice Wilson about how you view substantial competent evidence, because there is more to this. I mean, the district judge would have been able to assess the officer's credibility when he says this, seeing him on the witness stand, and make that credibility determination, which is appropriately for the district judge to make. But this issue was never presented to the district court, so there are no substantial. So you're hamstrung in the standard of review by reviewing this.
How does that fit with our standard of looking at what an objective officer would say? Why do we factor in what one of the two officers understood? I don't believe it was the officer that made the statement.
I don't know which officer it was, but certainly I think it helps. I mean, it helps explain what a reasonable officer would view. And I think when you get to the case law, there's more. That the point is that, at least from my point of view, as Justice Biles has said, the lawyer, we can characterize it all day long. The fact is that because it can be characterized in so many different ways, that in itself establishes that it was not a clear and unequivocal unambiguous invocation of his rights. The fact that we're going to have this discussion should be enough to tell you that, that wasn't clear. We don't have to determine what he actually meant. If it was capable of being interpreted reasonably in different ways, then it wasn't a clear invocation of his rights. And
Counsel, I think you're assuming the specific law enforcement officer understands the standard. And I'll direct you to Tammy Alexander's statement under questioning on page 28 to 29, where the question was, what do they got to do to stop the questioning? I mean, do they have to say no more? Or I want the lawyer right now? I mean, is there certain magic words that a person has to say to you? Her response, they have to indicate that they want to speak with their attorney before we question them further. Yes. Question, how about if they say, take me to jail? I'm done. I'm tired of you asking the same questions. That's not quite the same to you? Answer, no. How do you know that Tammy Alexander, the detective in this case, really understood what the standard was?
Well, two things. One, I don't think we really need to know whether she understood the standard so much as what we've pointed out is whether a reasonable officer would understand that. But I think you need to understand that questioning in context, because the questioning was all about whether he had asserted his right to counsel, not whether he asserted his right to remain silent. It's two different issues. And so she was being asked, would you take him saying, take me to jail, as a request for counsel? I don't think any reasonable person would construe that statement as a request for counsel. And so that's the context that she was being asked that question, which again gets us back to the problem of not having this issue raised below.
Also the importance of context, correct?
Yes, certainly. And beyond the things I've suggested, that I cited in the brief cases supporting other different interpretations of what he said. It could be just an expression of he's just angry, right? It could be just a recognition of the difficult predicament he was in, that he's going to jail. Courts have looked at similar statements in the context of those cases and said, those are not clear and unambiguous invocations of the right to remain silent. So like I said, I don't think I need to point to one case and say this is just like that case to win the point. The point is there are multiple different ways to have a reasonable person could have interpreted his statements. It was not a clear and unambiguous invocation of his right to remain silent. He knew how to do that because he later did it. He later said, okay, we need to be done talking now. I need to talk to my attorney or something to that effect. So
We agree with you that there's this factual overlay and this credibility or whatever the take, at least hearing the testimony of the officers, that's important. How do we deal with that when we have the unassigned error statute? I mean, is this a situation where you have a Van Cleve type of scenario that we ask for more fact-finding on an issue, or do we just go ahead and handle it de novo?
Well, I think Justice Stiegel said it in the Robinson opinion, is that you're stuck with the record as you have it. While you can review these unassigned errors, you have to do it with whatever records you have, and if the record isn't sufficient to show error, then you can't find error. Of course, the state still submits that the court has interpreted that statute too broadly, but I think that ship has sailed, so I don't see much point in me making that argument again, although we did put it in the brief, but these kinds of issues keep rising in these cases because of that broad interpretation of the statute. The state would submit the statute was intended to just be a plain error review. That being said, that also raises an interesting wrinkle with this case, because I think there is a preservation issue here that needs to be addressed, because the statute says that you can court can review unassigned errors in a case where there's a judgment of conviction that results in the death penalty. But here we have a hybrid case. We do have a capital conviction, but we also have a first-degree murder conviction, a second-degree murder conviction, and a firearms conviction that did not result in the death penalty. And therefore, the state submits the usual preservation rules apply to those charges, to those convictions, and that this issue cannot be considered as it relates to those convictions. It can only be considered as it relates to the capital murder convictions.
Does that statute, I'm sorry to interrupt you.
I was just going to say, as to the murders of Stout and White and the other crime, our argument is that this issue has been waived and barred by the failure to preserve it below.
And does that statute specify in death penalty matters or charges, or how does it describe?
As I was talking, I was struggling to find it in my notes here. Now I find it. It says the KSA 216619, the part I've quoted is it applies to a judgment of conviction resulting in a sentence of death. And I would submit a judgment of conviction that results in a sentence of death is only a capital murder conviction. Only the capital murder conviction results in the sentence of death. The others resulted in life sentences or a term of months according to the guidelines. So I would submit to the court that statute does not apply to those ordinary convictions. And so to the extent that we may have an error here, it's only going to apply to the capital murder conviction.
Counsel, isn't that just true if you define it very specifically only to the right to silence? If the error is worded such that it was reversible error to admit the custodial statement, that actually was addressed at the trial court, correct?
Well, the error, there's two different claims. At trial, they argued that it was a violation of his Sixth Amendment right to counsel. They invoked his right to counsel. On appeal, they're arguing that it was a violation of his invocation of his right to remain silent under the Fifth Amendment. Now, if we start conflating issues like that, I think it's going to upset a whole lot of appellate practice. We don't conflate issues like that. They're two separate issues. The issue that he has raised on appeal is not the issue that he raised below. And ordinarily, that would be the end of it. C.B. Englehart says that one cannot object on one ground at trial and then sort of different ground on appeal. That's well-settled law. And I think if you allow that sort of kind of inexact framing of issues and inexact framing of objections, we're going to undermine the whole purpose of the contemporaneous objection rule, the whole purpose of the appellate preservation rules, because then it's going to be anything goes. And then you're going to find yourself in more cases than just capital cases dealing with incomplete records, reviewing decisions that really the district court didn't make, and so you're going to be making decisions anew up here, which is really not the way the system is set up. And I mean, I can't tell you how to do your jobs, but the system is set up that this court does not make findings of fact and does not consider issues that weren't raised below, except in some very narrow circumstances, which the court has outlined in case law, when there's no dispute of fact, it's just purely a question of law, that kind of thing. I don't think we have that here. So, yeah, I think the way that it was framed below and the way that it's framed here matter. And it is not framed the same way at this level that was framed below. The objection below was different. It wasn't argued the way it is here. So back to my point, I think they've waived that under the traditional preservation rules for the non-capital cases. For the capital case, obviously, the statute allows, for the capital conviction, the statute allows the court to consider it. But, of course, the court is hamstrung by the record, or the sort of incomplete record.
If we disagree with you, and if we find that the statement should not have been admitted, can you address harmlessness as to all of the murder convictions and the penalty phase of the capital?
Certainly. That's the next slot on my outline.
Sorry about that.
You got me right to where I wanted to be. I guess the standard for harmlessness, I cited State v. Ward, is that we have to show there's no reasonable possibility that the error affected the verdict. I think when you look at the transcript, I don't believe he ever admitted in that interview that he committed the murders of KB and LB. I think he consistently denied that. So he really didn't. He never made a statement incriminating himself on those murders.
Let me interrupt you real quick. If we're in error land, the second interview goes out too, the one that started at 11:30 at night, the second interview. So I think your premise here is that we lose everything, not just what happened in the first interview.
Yes.
Okay.
Yeah.
Okay.
Yeah. So the only time that he lost my train of thought there. He never confessed to that murder, and I don't believe he ever confessed to the Stout murder. So to that extent, he never made an incriminating statement in this interview. So it would be the admission was harmless. Moreover, if you look at the circumstantial evidence, I submit that it's pretty overwhelming. I mean, first off, 4 people died at that house, and he was the last man standing. He was the only one there. That in itself is pretty strong circumstantial evidence that he was the perpetrator. He was the only one that walked away alive.
How do you know he was there the entire time that these murders occurred?
Well, I mean, we have his DNA evidence there. I mean, we have his DNA on the bandana that was around her neck. Now, given he lived there, so you'd expect to see his DNA evidence there. I believe the shotgun was determined to be his shotgun. And then we have the cell phone data. But of the people who lived or visited that house, he was the only one who walked away alive. So there's that. Then, like I said, we have the cell phone data that established, where he was. He was at the house on May 1st, I think, which is after everyone was killed, or when KB and LB were killed. Again, it was his shotgun. His DNA was found, and admittedly, the DNA in this case was not as strong as it is in other cases, but it was there. He was seen on camera in Emporia disposing of some of the items that belonged to the murder victims in a dumpster. He drove one of the victims' cars to Emporia. He was found in possession of the same kind of zip ties that were found binding KB's hands. So you look at all of that, the surveillance footage, the DNA, the cell phone data, and the fact that, he was the only one that, like I said, he's the only one that walked out of that house alive. It's a pretty strong indicator that he's the guy who committed the crimes.
Do you have other evidence to indicate that he walked in while they were still alive and had to have been the only one there?
Well, the only evidence that we have of other people being there, the only direct evidence we have, it comes from these very statements, which Mr. Flack was able to tell his story to the police and get that before the jury by the admission of these statements. And now I will admit that after after we reviewed this and reviewed the reply brief, yeah, we did make a mistake, and I think we missed the continuing objection at the very beginning of this when we made the argument that it was strategic. But certainly when it comes to harmlessness, I think we can look that defense counsel basically turned this into a strategy, though, by helping to bolster his case for somebody else being there. So to the extent that that evidence came in through these statements, it helped, it helped Flack's case, didn't hurt him. The only murder where this is close is the White murder, because he did confess to killing White. But again, the evidence was the circumstantial evidence was pretty strong. Who else could have done it but him? But again, I submit that with respect to that murder, this issue is not preserved because they didn't raise the same objection. And if there are no further questions on that,
I would like to ask one quick question. So with regard to the Miranda, you have the right to remain silent and the right to counsel. And what is the state's position about the right to end an interview without invoking, I know that they cited the Walker case, but there he did talk about silence. But what is the state's position on whether there is a right to terminate an interview by saying I want to terminate this interview versus I want to remain silent?
I think they're two sides of the same coin. I mean, the right to terminate the interview is linked to one of those two rights, the right to counsel, the right to remain silent. And you have to simply make an unambiguous, unequivocal invocation. So if you said, look, I want to terminate this interview, I am done talking, I don't want to talk anymore, something that is clear and unambiguous, that would end it. But
But do you have to say, I don't want to talk anymore? Can you just say, I want to end this interview right now?
I think that would probably be sufficient, but it has to be clear and unambiguous, which we don't have in this case. And if there are no further questions on that.
Let me ask you one other question on I'm sorry.
You're trying to move on, but
On the harmlessness side, take us to sentencing. If this evidence infected the guilt phase, doesn't it infect the sentencing phase, capital offense?
The same argument applies. The capital offense was just was the murder of KB and LB, which he didn't confess to in the statement. So I'm not sure how it could have harmed him in the penalty phase. And I mean, at that point, he was convicted anyway. I don't see anything in this interview that I think would impact the penalty phase. The penalty is about the proof of the aggravators.
Counsel, in the penalty phase, though, each individual juror is weighing the aggravators and the mitigators for themselves. There's no reasonable doubt standard as there would be in the guilt phase. So how would that not affect at least one of those jurors?
Well, because the question in the penalty phase is relatively narrow in some respects. First off, you can only consider the aggravating circumstances that have been proven. And the aggravating circumstance, there were two that were proven, that he killed more than one person and that he killed LB in a heinous, atrocious, and cruel manner. I don't think there's anything that in this interview that you can point to that affects either of those. And I don't think there's anything in there that undermines any of the mitigation. I mean, I just don't see how it's particularly relevant, him sitting there telling the police, I don't know anything, denying things repeatedly that really impacts that. I mean, there's nothing in there that comments on any of the mitigation. There's nothing in there that even really establishes the aggravators. To me, it's struggling to see.
Well, he put himself
relevance.
in the room when the murders occurred.
I'm sorry, say again.
His own statement placed him in the room when the killings occurred.
Well,
Right?
certainly, but I mean, the thing is that if that's error, if it's error, then it's error at the guilt phase. If it's not error at the guilt phase, then it's not error at the penalty phase. I mean, the same thing.
I have one more question on harmlessness, if I could. The jury found Flack guilty of second-degree murder concerning the killing of A.S. What impact, if any, does that fact have on our analysis of harmlessness? Does it suggest that maybe the jury had uncertainties about the manner in which A.S. was killed?
Well, I think it reflects that the jury, given the evidence, couldn't determine that it was premeditated because, again, I mean, the only evidence we had was circumstantial, and and Flack never admitted to. I mean, in these statements, he never admitted to killing him. So I think the jury determined that based on that, there was no way for them to determine. I mean, they determined he killed him, again, because who else could it have been, given the evidence, but there's no way to determine what was in his head when he did it, whether he thought it over beforehand or whether it just happened in like a fight or something like just happened quickly. That's my take on that. Shows that the jury was doing their job. They considered all the evidence carefully, and that's they realized that perhaps the state didn't carry its burden of proving beyond a reasonable doubt that he premeditated it.
So admission of his statements would be or would not be harmless?
It would be harmless because, again, they didn't go to that. I mean, he didn't, in the statement, he never, again, it helped his case, if anything, because he consistently denied it. He never made any statement within that interview that said, I killed him, or where he admitted that he premeditated it or anything. So, again, it's harmless. It didn't factor, the statement is not what convicted him. The statement is not what caused the jury to find him guilty of second-degree murder. So it had no impact on the verdict. And I think that's what the standard, to get myself back on track to the harmless error standard, there's no reasonable possibility that the error affected the verdict. I think there's no reasonable possibility that a statement where he doesn't incriminate himself led to him being found guilty, is kind of the argument in a nutshell. There are once again, if there are no further questions on that issue, I am prepared to talk about prosecutorial error. If there are no questions on those issues, since my opposing counsel didn't address them, I will simply yield the floor to my colleague. Being no questions, I'll yield the floor to my colleague who will address any questions with the other issues. Thank you very much.
I had planned on briefly addressing issue 3, but of course, if this court has questions, I think counsel had indicated a desire to perhaps address issue 5, so if there are questions on that, I'd be happy to answer that. Issue 3, essentially the state's issue with that issue, which is the juror issue, is that the reply brief and the opening brief are very different. In the opening brief, Flack takes issue with 16 veneer members. In the reply brief, he finds 4 more and makes it 18. I'm not typically, if we were in a regular non-capital murder case, raising an entirely new issue in a reply brief would be frowned upon and barred. I would like that same rule in capital murder cases. But regardless, 16, apparently the count was wrong. One of the for-cause challenges was actually, or the state used a preemptory challenge on one of the jurors. Another one never sat. She was an alternate that never made it onto the jury. So the math should have actually been 14 from the opening brief. In the reply brief, 18, even if you get to 18, it still has a problem where he had 20 preemptory strikes. He didn't use 2 of them. Under State v. Miller, he simply has no issue to raise. And here he entirely ignores the second voir dire and its purpose. The second voir dire actually removed one of the jurors that found him guilty, and he's essentially saying, well, that didn't matter, nothing. And then as to the 4 new challenges and everything else that is brand new, essentially he often just relies on the questionnaires, and this court has indicated that that is not fair to do. Jurors don't know the Kansas law death penalty procedure. When they fill out those questionnaires, you have to use what they actually said during jury selection. And finally, the 5 jurors that actually did sit, only 2 of which he actually challenged for cause below, were all fair and impartial. Oh, and by the way, the reply brief adds a new challenge to one of those jurors, which again should not be permitted. But regardless, he cannot prove that the jury that found him guilty was biased, and this issue should be denied. Unless there are questions on the other issues, that is all I have. And we would ask that you affirm Flack's convictions in this case, and if you want Mr. Ailesbury to come back, just let us know. Thank you.
Questions of either?
Thank you, Your Honor. Did I grab, excuse me. I would just note as to a couple of the points raised as to harmlessness in both, for issue 2 in both the penalty and guilt phase. My recollection is the state argued that they functionally relied on this final confession to create the narrative of these killings as to, certainly as to KB and LB. There's these assertions that Omar and Chewy, who are brought up there, don't exist, and Mr. Flack is essentially, that the jury can use the confession as a narrative for the killings, placing Mr. Flack in those roles. Certainly in penalty phase, I have in front of me in the penalty closing in volume 62, page 5945. The defendant tells you the scenario. The killing of KB occurred. What did he say? Detective Thompson asks him, where is LB? Where is LB? She's walking towards her mother. Her mother is dead. And so they're specifically relying on the confession in explaining the narrative of here, both to the aggravators and to, in guilt phase, the convictions.
Mr. Perkins, would you address the interaction we had with State's Counsel regarding preservation and unassigned errors, and how that would play out how it would play out on appeal? State's position is that there is a preservation problem as it pertains to 3 of the victims, and perhaps we could get to it through an unassigned error on the 2 capital homicides. How would that work, and do you agree with that kind of assessment?
I disagree with that kind of assessment. As we explained in our brief, and I briefly mentioned, I think there are already traditional preservation issues that are coming up here. The defense did object to this as to all convictions. Then I would refer back to just going into the capital preservation 216619, which of course ends with whether the ends of justice would be served, and we're talking about this. And this is a suppression issue that impacts all of the convictions equally. None of these are harmless, and the whole purpose behind 216619, I think, is to serve the ends of justice and to allow for speedy review in capital cases.
Well, it's a preservation issue as to how it was framed at the suppression hearing. It wasn't framed as an exercise of right to counsel as opposed to, or do we separate out, how do we separate out the right to remain silent, right to counsel, that really wasn't articulated at the suppression hearing, and well, how do we do that?
Well, one, it all also goes back to voluntariness, which was also brought up, which involves the invocation of rights amongst other factors, and so rights were invoked here unequivocally, and that is clearly preserved, and I think I would be arguing under that if this wasn't a capital case, but we also get there under capital preservation because this is an insular issue that requires reversal of all of the convictions, and the end of justice wouldn't be served by reversing on simply the capital conviction and then leaving for a subsequent habeas that would happen after a remand for the capital conviction on whether or not it was preserved or counsel was ineffective for failing to raise that. This is one of those cases where all of these convictions should be reversed. Further on to a couple of the other points of the harmlessness here, the state addresses this argument that Mr. Flack is the last person in the house. That is not even correct in this case. There are many people in and out of this house. Mr. Phillips visited there, but moreover, there are about a half dozen people, including police officers, that were in this house before these homicides were discovered, before the bodies here were discovered. There were people going into the bedroom where the bodies are, and they didn't even realize that bodies were there. So just because the state can place Mr. Flack in this house isn't a strong inference. There are other people in this house who don't realize killings have occurred. So that same inference can be drawn to Mr. Flack even though he's in that house. Because moreover, I would like to return just to another piece of this sort of inferential case that I think I explained poorly on my first stage, which is the cell phone evidence, because one of the facts that the state refers to for sort of their premeditation argument is about text messages that they've received, right? They assert that Mr. Flack must have premeditated because there's a text message to Dylan Phillips that says, like, we're not babysitting tonight. But the state's argument is also premised on the idea that this inference then is that AS has to have already been dead before May 1st. And therefore, because there are text messages coming from AS's phone, that has to mean that that's somehow Mr. Flack doing that, even though there's no evidence of Mr. Flack having AS's phone. But even after that text message from Mr. Flack to Mr. Phillips, you have text messages to AS that AS sent to Mr. Phillips saying, you can come over and get your stuff on May 2nd, or Mr. Phillips's mother can come over and get stuff on May 2nd because he'll be there. AS will be there. So it's not like there is some clear point where there's a cover-up happening via these text messages. There's text messages from AS saying, come over to the house, well after the point where the state's narrative is acting like he must have been dead. There are about 50 text messages between AS and KB who are in a relationship over the days that the state says that they were dead. And there's nothing in the record that is talking about even a suspicious text message from AS until May 2nd, which was a text message, I think, to Mr. Helm talking about video games that seemed off. So even this premeditation argument based on those text messages is inferential and troubling. And I think, in conclusion, I would return to the impact of both Issue 1 and Issue 2, though there are many other significant issues that we did address in our briefs, because this was a case that went to trial with a defense team that was repeatedly making a record of the fact that they were unprepared for trial in both the guilt and penalty phases. In the fact phase, defense counsel had not even completed review of discovery, let alone investigation, where there are real questions of Mr. Flack's guilt or culpability, where there is DNA from an unidentified third party on the handkerchief that gagged KB, under her fingernails, in her pubic combings, and on the forearm grip of the murder weapon, where there is someone else moving AS's cell phone near where LB's body was discovered at the time that Mr. Flack was in Emporia. And in the mitigation phase, defense counsel had not even completed a social history necessary to investigation, and on the eve of trial had not been able to develop a thoughtful and informed theory of mitigation. Then we have the state's case built upon a confession obtained after interrogating officers ignored Mr. Flack's repeated invocation of his right to end interrogation by repeatedly answering questions, take me to jail, take me to jail, take me to jail. And without that confession, the state is left with a case built upon circumstances and weak inferences, where the state cannot place Mr. Flack in that room and DNA evidence that has weak exclusion rates to Mr. Flack and also cannot exclude AS, and where we have DNA from at least one identified male third party in multiple locations intimately tied to these crimes, and cell records of them disposing evidence. It's in this context that I ask that you find the state has not carried its burden to prove beyond a reasonable doubt that these errors are harmless, and reverse Mr. Flack's convictions and sentence of death and remand for a new trial. That is the end of my prepared remarks, if there.
I have a quick question. At least I think it'll be quick. I want to take you back to sort of the procedural standard of review that we've touched on with respect to the facts of the interview. And I think that you said in your initial presentation that the facts are not disputed because we have a transcript and a video, and so we basically have a de novo review. And I wanted to ask you, or give you an opportunity to answer the same question I asked the state, which is the officer's testimony about the interview also part of the uncontested facts that we should look at?
Yes, I believe the officer's testimony is part of the undisputed facts.
So we should take the officer's testimony as true about what the officer thought was happening in the interview.
Yes, with 2 points. One, what the officer said you can take as true, but the question here is whether an objectively reasonable officer in those circumstances.
It doesn't change the legal standard, but you're not suggesting that we shouldn't consider that what the officer testified to is somehow untrue.
Correct, though my other clarification is I think the quotes, or at least the first quote read, was from Detective Thompson, who was not the detective at these invocations. He was a detective in the subsequent interviews.
Thank you.
Anything else? Okay. Thank you to both counsel for your arguments today. The court will take this matter under advisement. Court is now in recess until tomorrow morning at 9 a.m.